Greatest of mornings, all. We are here for our Sunday sessions with the Education Esquire. We are going to be getting started in approximately 3 minutes, as it is that time of the week, and looking forward to another outstanding workshop. Going to start going to Facebook Live right now. So, live on Facebook. Sunday sessions with the Education Esquire. Part 2 of the trust workshop and podcast. Okay, according to the Facebook post, it is preparing to go live right now, setting up meeting, says done, redirecting to Facebook Live. So greatest of mornings, everyone. It is 8:58 a.m. We are here with our Sunday sessions with the Education Esquire per our usual Sunday morning at 9 a.m. Today, we're going to be talking about the second part of the trust conversation. We're going to be looking at how you fund your trust, and more importantly, some of the steps that need to be taken. It's not enough to simply have a trust set up. You actually have to go through secondary or even tertiary steps to make sure that the trust is working as you desire it to. So the trust is a vehicle that gets you to a destination. And like with any vehicle, you go to the car dealership, pick out the one that you like most, and then you purchase it. But it's not enough that you've purchased the vehicle, you have to put gas in it. And that's what we're going to be talking about today, gassing or fueling your trust to ensure that it does what you want it to do. So I'm going to make sure that it is available to the public. Now it appears that it's available to the public. It's 8:59 a.m. We're going to be starting right at 9 o'clock. Greatest of mornings to each and every one of you. And if, as always, if there are any specific questions that anyone has, whether it be from last week's conversation or if it is just in general, always feel free to post those in the chat group. You can also comment, whatever it is that's most convenient and available for you. So we're going to be getting started at 9 a.m. on the dot, and it's 9 a.m. Okay, so we are going to get started. Last week, we had the conversation about trust, and it was really an introductory discussion, talking about some of the specifics as to what steps need to be taken, the importance of actually placing your property in trust. So I'm going to do a quick recap. The first 10 minutes or so is going to be a recap of what we discussed last week. So I'm going to share my screen, and in sharing my screen, we are going to take a look at the property records. So last week we talked about how that trust actually works and really what the importance of it is. So in the event that you have a property and you are interested in protecting that property, which is one of the biggest benefits of a trust, placing that property in trust helps to prevent the public from knowing who the owner is. So when we look at the property here at 17807 Locust Street in Lansing, Illinois, the tax bill shows the 17807 Locust Street Revocable Living Trust. That means that the trust owns this property. It's not an individual. What that looks like in terms of, from the standpoint of the deed, is when someone goes and searches for the deed at cookcountyclerkil.gov, clicks on recordings, clicks on search recordings, then types in the 14-digit PIN, which is 2936. All right, let's get this out of here. 2936 200157. The public record is only going to pull up this. So we have a warranty deed that shows that it went from the bank, which owned the property, and then it shows that we have the name of the trust. So we have here on the deed where it shows that the property was conveyed from the grantor, which is McCormick 103 LLC, a limited liability company, and then it was conveyed to the 17807 Locust Street Revocable Living Trust. So that's what it is that the trust offers. No one is able to ascertain who is the physical or the individual who's the owner of this property. That's important because if the owner, the individual, ever needs to go onto Medicaid or ever is in a car accident with the 10-car pileup and unable to pay all of the expense that goes along with that 10-car pileup, this property is now not subject to any type of lawsuit or issues. Now, one of the other instances that I always like to point out is when you have multiple properties, it is incredibly important that you have separate trust per property. And the reason why is because the city of Chicago is a prime example. They are relentless at ensuring that if an individual owns multiple properties and gets a violation against one of those properties, they are going to place the liens and violations against all of those properties, even if they're not in the state of Illinois. We've seen individuals who own properties in the city of Chicago and then walked away from those properties, only for the city of Chicago to knock the property down, physically raise the structure that was on the property, and then charge the owner for knocking down their property. In doing so, they then posted that judgment for knocking down the property against all 8 of the property owners' additional properties, some of which are in the suburbs, some of which are in the city, 2 of which are in Mississippi. That is the danger of having multiple properties owned by one entity, whether it's a person, whether it's an LLC that's not a series, or whether it is even the same trust. The desire and goal is that each particular property needs its own owner so as to prevent other cross liability issues that happen with one of the properties happening to the other. Now, in returning to the conversation, let's talk about how we fund that trust. So you've got your trust, you had it set up, whether you do it yourself or whether you go to a professional. It's not enough to simply it's not enough to have the trust. You have to actually fund the trust, and that can happen through a variety of things. Typically, the easiest route is to place the property in trust. So in the case of the 17807 Locust Street Revocable Living Trust, it now is funded because it has what's called consideration. Consideration is something of value. It can be $10, it can be $5, it can be a checking account that has $300 in it. It could be a house, it can be a vehicle. Any one of those different instances is how you fund the trust, but it actually has to have the value in it. For our trust, and I'm going to show you what that looks like in our case, what we always do is we fund the trust instantly with $5. So we take a $5 bill, trust, and I'm going to pull it up so you can see what that looks like. We take a $5 bill and we attach it right to the trust agreement itself. This way, there is actual consideration that has been conveyed to the trust itself. So I'm going to stop sharing that screen, and then I'm going to start sharing this one. So this is what the trust looks like. So this is the document itself, and this is a physical. So the physical document has the $5 on it. So we have this attachment A, which indicates that the 17104 Kenwood Ave Revocable Living Trust, which was dated June 25th of 2015, has been funded with $5. By taking and attaching the literal $5 bill to the trust agreement, that ensures that the trust was funded. The reason we do this is because oftentimes when you are having a property transferred into the trust, it takes some time. Depending upon which municipality it's in, they oftentimes have transfer stamp requirements. They also have they possibly have requirements that the house has to be inspected. All of those create issues that prevent the house from being transferred in immediately. So in order to prevent any issues, with the trust being funded, we just take $5, stick it right onto the trust agreement, and now this trust is funded. When we talk about funding a trust, we're saying giving money or consideration to the trust itself. I'm taking it out of Mario Reed's name and I'm putting it into the trust name or trust ownership. This is an essential step, which unfortunately far too many people forget to do. When individuals are going on to LegalZoom, this is a common mistake that's made. When individuals are even going to other attorneys, this is a common mistake that a lot of attorneys fail to actually do. The trust must be funded in accordance with the Illinois Trust Code, as well as the Universal Trust Code that kind of governs all trust or the majority of trust throughout the United States of America. So that's a step that needs to be done. Now, one of the other things that a lot of people are unaware of that is available with the trust is that you can add the trust as a beneficiary. So I'm going to go back to the trust agreement and I'm going to pull it up and I'm going to. So last week we talked about the trust having its own taxpayer identification number. With that taxpayer identification number, it ensures that you can add the trust as a beneficiary for any assets that you are interested in having. So I'm going to show you that taxpayer identification number once again so that you can see it. So share on the screen. Okay, so here is the trust taxpayer identification number. So we've got the 17104 Kenwood Ave Revocable Living Trust, and this trust has its own taxpayer identification number. You'll see here that it says employer identification number. Because the trust is not an employer, that's the reason why I'm not referring to it as an employer identification number. The trust is an entity. It's a legal entity, just like a corporation, but like an individual. And because of that, this is the taxpayer identification number, which is the tantamount or equivalency to the Social Security number. So we've got this employer identification number, taxpayer identification number, Social Security number for the trust. This is the number that we're going to use whenever we are seeking to list the trust as a beneficiary or as an account owner. You have two different methods that you can go about when using a trust. The ideal way is that you go into the bank and you say, hey, bank, I'm interested in opening a checking account for my trust. And when doing so, you're going to provide them with similar information that you would if you were opening it up for a business. So I'm going to kind of walk you through what that process looks like here. So we have, how do I open a checking account for my trust? So the first step is you have to find a bank that actually does this. This is one of the problems that we frequently run into in the practice, is that a lot of banks, because they don't do this very frequently, especially in certain communities, they are unaware or unfamiliar with how to open up a checking account in the name of the trust. So what you're going to do, and you'll see here, LegalZoom is a great resource for explaining it, but you will need to bring your certification of trust and or the trust agreement itself. The bank will have you complete a new signature card for the account, and the account will be held in your name as trustee for the trust. The bank will also require a taxpayer identification number of the trust, what we just covered. So the bank is going to be looking for either a certification of trust or the trust agreement. What the difference in those two documents, there are several differences, but what the primary difference is between those two documents is that a certification of trust is a shortened, truncated version of your trust agreement. And it says specific details about the trust. So it explains, and you know what, I'm just going to show you. So in the state of Illinois, we have the Illinois Trust Code. And inside of the Illinois Trust Code, it talks about what should be in the certification of trust. So that's 760 ILCS 3/1013. So here it is. So a certification of trust. Instead of furnishing a copy of the trust agreement to a person other than a beneficiary, the trustee may furnish to the person a certification of trust containing the following information. So they have to have a statement that the trust exists and the date the trust instrument was executed. It has to have the identity of the settlor. The settlor is the person who's creating the trust. So for the 17104 Kenwood Ave Revocable Living Trust, I am the settlor. I was the settlor because it's already created. And I'm the one who said, I want to create this trust. So I'm the settlor, so my identity would be listed. The identity and address of the currently acting trustee. Once again, because it's my trust that I'm serving as the trustee, that's going to be my information. The revocability or irrevocability of the trust, whether the trust is amendable or unamendable, and the identity of any person holding a power to revoke the trust. This is one of the biggest aspects that has to be specific to your individual trust. Our firm typically uses revocable living trust. That's because we want for it to be amendable. We also want for the individual who's the grantor settlor to also serve as the trustee and the beneficiary during her or his or their lifetimes. However, we do assist with Medicaid trust or irrevocable trust. An irrevocable trust is a trust that has to have a certain provision or provisions which are not capable of being amended. When it comes to an irrevocable trust for Medicaid purposes, the settlor cannot be the trustee nor the beneficiary. So in instances when someone's seeking to prevent their house from being able to be liened because they are signing up for Medicaid, the house they can't be listed as the beneficiary nor the trustee for the trust. This is a major risk on the part of the individual, because once you cede control as the trustee and the beneficiary to a third party, that individual now becomes essentially the quasi-owner of your property. This is what happens in instances of Medicaid. It's also what happens in instances of certain, not really for lawsuits, but Medicaid is the primary one, but other governmental entities have the same piercing of a trust capability, which is why it needs to be an irrevocable trust. You also need to specify the authority of the co-trustees to sign or otherwise authenticate, and whether all or less than all are required in order to exercise power of the trustee. The trust taxpayer identification numbers to be included, the manner of taking title to trust property. They give a sample breakdown of what the certification of trust can look like. It says a certification of trust may be substantially as follows, but nothing in this subsection invalidates or bars the use of a certification of trust in any other or different form. So they're looking for name of the trust, date trust instrument was executed, taxpayer identification number of trust, the name or settlor of trust, the currently acting trustee, addresses, who's authorized, how is the property supposed to be taken? Is this a revocable or irrevocable trust? Is it an unamendable or is it an amendable trust? All of this is information that should be in there. You'll notice that there's no mentioning about beneficiaries. There's no mentioning about who's supposed to get what percentage. There's no mentioning about any of the special stipulations or qualifications or requirements that are applicable. This is the virtue of the certification of trust. A lot of times agencies, whether they be governmental agencies, whether they be third-party companies, banks, financial institutions, they think that they have to have the trust agreement. But as you can see, this comes directly from the law, 760 Illinois Compiled Statutes 3/1013. It explicitly states that instead of furnishing a copy of the trust instrument, a person other than a beneficiary, the trustee may furnish to the person a certification of trust. That's all that has to be provided. What the state is saying is that instead of giving people all a bank or an insurance company or the assessor's office or the treasurer's office, instead of giving them all of your personal details related to a trust, give them a truncated version. Give them just the basic and maximum minimum that they need. That's the most information that they need. And that's one of the virtues of the trust option, is that it allows you to continue to keep your details private. Instead of telling everybody what your business is and what's going on with the trust, just give them the minimum. So I'm going to pause here to see if we have any questions. So I've been going for about 15 minutes, and this is usually when I like to check in to see, do we have any questions? We've discussed the funding and the importance of it. So I'm now here to see any questions. If so, feel free to post. If not, I'm going to keep on going. Okay, so I am not seeing any. So we are going to return. So we have our certification of trust. You're going to take your certification of trust into the bank. It's a document, and I'm going to pull up one really quickly so you can kind of see what that looks like. For this one, I'm only going to flash it really quickly because it's not my personal one. And I don't always like putting everybody else's business out in the world. So I'm going to show you certification of trust for, do it for this client. Okay, so I mentioned that certification of trust. Here is a look at a certification of trust. This is one that our firm, this is the format that our firm uses. So this is what it is that this client would be taken into the bank. It specifies all of the details of the trust agreement, and then it would have the taxpayer identification number. It's signed by the client, the trustee, and then it's also notarized. This is what a certification of trust looks like. As you can see, it's only 6 pages. It's much shorter than the 28-page trust agreement. So the client or the individual, because of course you can do this yourself, is going to take this document into the bank and then say, hey, bank, I want to open up a checking account in the name of my trust. That is going to then allow for the bank to have all the documentation they need to open up a checking account. That checking account is going to be named after your trust, whatever the name of your trust. So in my case, it would be named the 17104 Kenwood Ave Revocable Living Trust, dated June 25th of 2015. I'm the trustee. So underneath the name of the trust, it's going to state my name with the TTEE behind it, indicating that I'm the trustee. I'm the authorized signer. I'm the one who can then deposit checks, write checks. I can do anything that a normal person would do with their checking account. I can send money via Zelle. I can receive money via Zelle. It is a new account. I can set that checking account up for direct deposit. So let's say that I have an employer and I want for my money from my employer to go to my trust as opposed to me. I can do that. You'll have to check with your employer to see if they're willing to do it, but so long as they're willing to do it, then you can have those funds go directly into your trust. Now, a lot of people will say, well, why would I want that money to go into my trust as opposed to my money? The reason why is, once again, because of liability. If you ever go on Medicaid, if you ever are in a car accident, if you ever are sued, remember OJ. OJ was able to keep all of his money because the money was going or went to a trust as opposed to OJ. So then OJ gets sued, OJ loses the civil suit, and then the families of the deceased go after OJ's money. OJ has no money. OJ's trust has all of the money, so that money is safe and can't be touched. Now, one of the other things that you absolutely want to do, as I've discussed, is you want to set up the beneficiaries on your account. And in setting up the beneficiaries on all of your accounts, every single account you have needs a beneficiary. If it's a checking account, if it's a savings account, if it's an insurance policy, if it's an annuity, if it's an investment, if it's a stock, if it's a bond, if it's a government bond, if it is a stash account, every single account needs to have a beneficiary. There are various ways that you can do this. Last week, I talked about doing it with the bank. I'm going to now show you once again what that looks like. So for your bank, and I'm just going to pull up mine. So I'm going to stop sharing because I don't want people knowing my banking information, my signing information, but I am going to pull it back up once we have everything going. So I use Bank of America, and in using Bank of America, it gives the option to add a beneficiary right online. This is one of the most helpful things available. So give me 1 second because I'm going to try and figure out how to show this. Okay, perfect. All right. So I'm back to sharing screen. Okay, so I have signed in to my Bank of America checking account information. You'll see here that it says Bank of America online banking. So right now through Bank of America, you can go right online and you can add a beneficiary. You have to sign in, and then in my case, right up at the top, it showed beneficiaries. I clicked on that. I actually did this on my phone initially, but I'm on the computer to show you what you can do. It's up to you to determine whether or not your bank offers it, but this is what it will look like. So I come in here to beneficiaries, and then it shows that for my checking account, the beneficiary is the 17104 Kenwood Ave Revocable Living Trust. Let's say that I wanted to add a new beneficiary. I then can specify whether or not it's an individual or if it's going to be a business, a non-for-profit, or a trust. This is the virtue of adding beneficiaries. You can list a business. If you own a business and you want your business to be the beneficiary, you can do that. If you own a non-for-profit, or if you just believe in a non-for-profit, you can then list the nonprofit as your beneficiary. And then as we discussed, the trust. So in this instance, I would select trust, and then I'm going to put the full legal name. So let's say that I wanted to split 50% between the 17104 Kenwood Ave Revocable Living Trust, and I wanted to give the other 50% to the 17807 Locust Street Revocable Living Trust, or let's say I wanted to do a third to 17104, a third to 17807 Locust, and a third to Ardoma Housing Solutions. I have the luxury of being able to do so. What I would do is I would type in the name. So we have the 17807 Locust Street Revocable Living Trust, dated, I believe it was dated June 12th of 2019. So you're going to type in, nope, it was 2020. Was it 2019? Yeah, it's 2020. Okay, so you're going to type in the full name of the trust, and then you're going to type in the EIN or TIN, taxpayer identification number for the trust. It's that number that I was showing before. Let's just do 86754. That's not the number. I don't know it off the top of my head, but I'm just typing in something. Then it's going to ask you to add an address. So we're going to put in the address of the property. 60438. And then we're going to add the address. Can't forget the country. God dang it. So 17807 Locust Street, Lansing, Illinois, 60438. Okay, so now we've added it. We're going to use the USPS and we're going to confirm. So we have the name of the trust, we have the taxpayer identification number for the trust, and we have the address for the trust. Then it says, please make a note or print what you've entered about each beneficiary for your records. In order to protect this sensitive information, we will only display your beneficiary's name when you review or make updates. Your payable on death, POD, beneficiary information must be complete and accurate to be legally binding. By clicking save, I, Mario Reed, authorize for myself and other account owners that this information is correct, and I, we agree to the beneficiary addendum notice. It's wise to take a look. Take a look at that beneficiary addendum notice, and it says, during my lifetime, I may withdraw the money in the account. I may change the beneficiaries at any time. Upon my death, the money remaining in the account will belong to the then surviving beneficiaries in equal shares and will not be inherited by my heirs or controlled by my will. This takes precedent over a will. This takes precedent over even if the asset has been left in the trust to someone else. Having a beneficiary on your checking account, your insurance account, your savings account, your investment accounts, all of your assets takes precedent over all other estate planning. So no matter what else the other documents say, if there's a conflict, the beneficiary takes precedent. That's the importance of doing it. That's also the importance of listing the trust as the beneficiary. So then we click OK, and then I would hit save. I don't want to leave any additional portion to that other trust because that other trust is set. Have a life insurance policy that's going to there for $300,000. So that's the money that I want to go in there. And that's primarily going to cover the property taxes as well as maintaining it, the insurance, the annuities, all of those different things for that property. So I'm going to hit cancel. And in hitting cancel, I only want the money to go to the 17104 Kenwood Ave Living Trust. So now my beneficiary is set up. That's what you have to do for all of your assets. It's not enough to have a trust. You have to actually fund the trust, and then you have to list the trust as the beneficiary. So now people talk about other accounts. So one of the clients that we worked with this past Friday has a stash account. So what you're going to do is you're going to go to stash account, just go to Google, type in stash account, beneficiary, designation. And then how do I add a beneficiary to my account? Beautiful. Google is a phenomenal resource. Just ask it the question that you want an answer to. And I'd say 3 out of 4 times, it's going to give you an accurate answer relatively quickly. So if you have a stash account, let's say it's an investment account or even a Robinhood or E-Trade, any of these different accounts, you're going to just ask Google, how do I add a beneficiary to that account? Google's then going to usually take you to the page or the document where you can do so. So in this case, you'll see once again, transfer on death beneficiary designation form. We're going to go here and it's going to pull up the PDF. And here is the form that we're going to be using to add the trust as the beneficiary for our stash account. So you're going to fill in this information, your name, you're going to fill in the Apex account number, you're going to fill in your social security number, you're going to fill in your date of birth. Then you're going to check the box which says an original TOD. If you're changing it, you would select a beneficiary designation change. But in this case, we are looking to add an original transfer on death beneficiary. Then you're going to list the name. In my case, I would put the 17104 Kenwood Ave Living Trust. It then gives you the option to add the share percentage. If you want to split it multiple ways between multiple trusts, you can do so. In my case, I would put 100%. When it says relationship, the answer is my trust. The address, the telephone number, list your telephone number, list the date of birth is going to be the date the trust was created, not your date of birth. It's going to be the date in which the trust was created. And then the social security number or taxpayer ID number is going to be that taxpayer identification number. So once you fill that out, you're good. You're then going to sign this, but note, it must be signed in the presence of a notary. This is one of the things that a lot of beneficiary designation forms requires. This is why it's wise to make sure that you are getting everything kind of collected and bundled up together. So instead of making multiple trips to a notary, you can do it all at one time. You're going to take all of these beneficiary designation forms in, and then you're going to sign them in front of the notary public. So then the notary is going to fill out this section, County of Cook, State of Illinois, on this 27th day of February, the year 2022. Before me personally came the person. And if there's multiple people, that other one to be known to be the individuals described in and who executed the forthright instrument, and he, she, they duly acknowledged to me that he, she, they executed the same. In my case, I would sign as a notary public. I'd hit it with my notary stamp, and now you're done with the completion of the document. The next step is that you have to get it to the company. And unfortunately, this one is not showing where it's supposed to be sent. So let's go back to Google, and there we go. So it tells us if you would like to add a beneficiary to your Stash Retire account, please fill out this form and email it to support@Stash. Both the beneficiary form for your Stash Retire and your Stash Investment account will require your account number. There you go. So it's giving us the details on where to send it. So you send that to support@stash.com. And now your trust has been added as a beneficiary for your Stash account. This is another manner in which the trust is going to be funded, because whatever you have in your retirement account, when you pass, the trust is now going to receive those assets. It will flow right to that checking account. That's the virtue and advantage of setting up the checking account during your lifetime, is that you've made it easier for your successor trustee to get the funds from stash over to the checking account. All your successor trustee is going to do is call up stash and say, hey, stash, this person passed away, and then send them the death certificate. Stash is going to say my condolences for your loss, and then transfer the funds from the stash retirement account into the trust checking account. It is just that easy. No probate court, no having to reach out to attorneys, no having to pay court fees, no going before judges. They call stash, present a death certificate, stash transfers the funds into the checking account, which is already established in the name of the trust. Now, for those people who say, well, I'm not really interested in going through the headache of setting up a checking account for my trust while I'm alive, that's okay as well, because the successor trustee is going to be able to then handle that step for you. In doing so, that will enable for them to have the funds transferred right over. So the trust checking account isn't a requirement to be set up during your lifetime. It can be done after you've passed. It's just one of those things where, again, you're seeking to make the successor trustee's life as easy as possible, because they're going to be carrying out your wishes. And depending upon if you've given them funds for their time, effort, and energy, they may be a bit reluctant to go through these extra steps. I have clients all the time. I just recently got off the phone yesterday with one where her god sister was listed as the successor trustee, but the successor trustee, her god sister, did not want to have the responsibility as successor trustee. So right after her mother died, the successor trustee went to a firm out in LaGrange, Illinois, and said, hey, I want you to help me resign as trustee immediately. The mother asked that the god sister take care of the property for approximately 2 years following her death, to make sure that the daughter wouldn't just be kind of irresponsible with the property. Unfortunately, the mother apparently never went and got a commitment from the god sister. So when the mother died, the god sister said, I'm out of here, within 2 months of everything kind of shaken out. Now, thankfully, everybody was in agreement and there were no issues and they were able to transition it smoothly. I represented the daughter and actually kind of assuming the responsibilities as the trustee. But that's part of what goes into a trust, is that it's not enough to just say, hey, I'm going to choose this person to be my trustee. It's a good idea to have the conversation so that that way you have a buy-in. It's also a great idea to give them something for their time, effort, and energy, whether it's $1,000, whether it's 10% of whatever the trust is bringing in. Give them something to say, thank you for carrying out my wishes, because it involves work, a lot of work sometimes, communicating back and forth with banks, communicating back and forth with realtors, whomever it is that's going to be involved with the process. All right, so I'm going to pause and see if we have any questions, and we do. So greatest of mornings to you, Mr. Hill. Okay, for clarification, if you put rental property in a trust and get that EIN/TIN number, then I assume that the economy actively of the rental is, so I'm guessing the funds of the rental is reported on a 1041 return versus an individual's 1040. So that's a great question. And as a tax expert, you are right, spot on with what it is that they're going to be looking at. Remember, the trust is an entity. The trust is essentially like a child. Think of the trust of having a child that becomes an adult instantly whenever it is that you give rental property to the trust. If the trust is generating over the minimum amount that the Internal Revenue Service is looking that any entity files a tax return for, then that's what it is that's going to be reported. So the trust is no different than a human being. And if a human being has a rental property that's generating enough income where it now would be required to file a tax return, it's going to be the same way. So yes, you're right. It would be a 1041 return because it's a separate entity. Now, as that tax expert, you're very familiar with, it's only on the gain. So when it comes to that rental property, there's going to be all of those offsets. So if there's a mortgage associated, that offsets. If all those utilities, if they're being paid by the property owner or the trust, that's an offset. It's a great idea to get all of those utilities and everything into the name of the trust, because it makes the accounting and the bookkeeping and the record keeping a lot easier. All those property taxes are offset by the trust. Any maintenance costs are offset by the trust. Any legal expenses are offset for the trust. So oftentimes, as I'm sure, again, you're very well aware, it's not always going to be a scenario where the trust is going to be paying or having to file that return, because very frequently there's going to be so much in overhead where the gain is going to be minimal. And if that's the case, just like in the case of a business, that then is going to adjust or change what that filing looks like. But to answer your question, yes, sir, it would be the name and the taxpayer identification number of whomever has the ownership interest or is responsible for it. So that's a great question. Any other questions? And thanks so much for that question, because people oftentimes get a little bit confused when it comes to, oh, I have a trust, but I'm still myself. The trust is another legal entity, as long as you're using it as another legal entity, just like in the case of the business. As long as it's being used like another legal entity, then it takes on its own set of requirements and responsibilities, just like any other legal entity would. So great question. Any other questions? If you own shares in a cooperative that gives you access to your unit, but not ownership of the unit, how should you proceed? Do you need an LLC? Should it be placed in trust? So that's a great question. And cooperatives are very, very unique because they're unlike the other traditional property ownership. If you own shares in a cooperative, then it's just like owning shares in a company, whether it be Walmart or Target or McDonald's. You have an ownership interest in the corporation, in this case, the cooperative, of those shares. Depending upon what the corporate bylaws or the cooperative bylaws are, that's going to determine what ownership interest or what ownership entity can be used to own those shares. My recommendation is definitely to own those shares in the name of a trust, because once again, the trust takes care of the estate plan. If you own shares individually, whether it be in a cooperative or whether it be in a corporation, whether it be in a company, if you die, those shares now belong to your estate. And depending upon how valuable those shares are, they might have to go through probate court. If it's determined that those shares, or not only those shares, but other assets that you own total more than $100,000, by law, in accordance with the Probate Act, your estate now has to go through probate court. Your executor or your independent administrator is going to have to pay a bond. They're going to have to take out publication. They're going to have to deal with creditors. They're going to have to pay legal fees. They're going to have to pay court costs. Whereas if a trust owns those shares, inside of your trust agreement, you've already specified who you want to take over, who you want to receive those shares. And not just those shares, but all of the assets from your estate and anything that's owned by the trust. So having a trust as the owner of all assets builds in the estate planning. People don't have inherent estate planning, because when we're born, it's not like we set forth the details on who we want to get things. A trust is inherently about estate planning. So when a trust is created, from the beginning, it's saying if something happens to the person who has the ownership reins, we want for it to go to this beneficiary. Now, a lot of people say, well, can I do that with an LLC? The answer is yes, you absolutely can do it with an LLC. But what I always ask of an individual is, why do you want your personal business associated with the public record? When you have a limited liability company, you have to advertise to the world who the managing member is. So I'm just going to pull up an example again, and I'm going to make sure that everyone is still seeing the screen. So give me 1 second. I'm going to come over here and check to make sure. Okay, yep, it looks like. So everyone should be seeing the tab. So we're going to go to the Illinois Secretary of State Business Search. And this is something that virtually every state has the capabilities to do. But we're going to go to the Illinois Secretary of State Business Search, and then we're going to search for a business. And I'm going to search for, let's do the Lumarti Law Group. Okay, so we have the Lumarti Law Group, and you're going to see here that we have the registered agent. Now, in this case, because our firm is the registered agent for the Lumarti Law Group, it's showing our information. It's also going to show that the managing member is Mario A. Reed. That puts my personal information out in the public record. With an LLC, you have to indicate who the managing member is. You have to indicate the address of the principal place of business. You also have to indicate the name and address of the registered agent. You don't have to do that with the trust. So it once again keeps all of your information private. The other thing is that when you set up an LLC, you don't do estate planning. We hear from clients all the time who say, you know what, I can just go to the Secretary of State and I can set up my own LLC. And the answer is yes, you can. You can pay the $150 and then you can go through the process. But what you don't typically do is do the succession planning for your LLC. And the reason why is because you don't even know that you need to do that. So if you put those shares in the name of the LLC, but you have not named a successor to take over the LLC should something happen to you, then your estate is right in the same place as if though you had those shares in your name. They have to go through the probate process because they have to be declared as the heirs of your estate to then take over the reins as the LLC, and then they can get the shares. So the trust has so many more benefits. The other thing is that with the LLC, if you haven't done succession planning, it's then going to go equally to all of your heirs. Whereas if you only want the business or the shares of the co-op to go to one individual, that's where the trust comes in. We get so many people who say, well, I have this co-op and I trust that my oldest is going to do right by it. Well, you need to establish the oldest as the successor trustee and as the beneficiary, so that way she or he is in a position to be able to carry out those wishes. That's the virtue of a trust. By having the trust own the shares in the cooperative, you now get to handle all of your estate planning. You also now get to protect those shares from any creditors, any judgments, even the state with Medicaid. So that's a great question. Any other questions? And thanks for both of those questions. Any other questions? So pausing here, we're at 9:45, another 15 minutes in. If there are any questions, feel free to post. If not, we're going to keep on moving. Okay, so one of the next things that we want to do is for all of those insurance policies. So let's go to MetLife. How do I add my trust to my MetLife insurance policy? Okay, so we're here at MetLife. I don't have MetLife. I just chose that. Shout out to those people who work in MetLife. Good people work in MetLife. So life insurance change of beneficiary, MetLife's e-forms. Insurance providers are getting really progressive in this regard. It's one of the things that I'm most thankful for, because as an estate planning attorney, I want to help my clients as much as possible, but I can't, or technically I could. I could do the forms for them, but then that would be a separate charge. And a lot of people will say, well, why am I paying an attorney $250 an hour to fill out a form that I can fill out? And I agree. That's the reason why we typically don't do that, because I don't want to charge someone $250 to fill out a form that they can do so. But if they simply refuse to do so or say, I don't have the time for it, no problem. We'll charge you $250 to fill it out. So we come here, and now we're right here at MetLife, and we're going to go to the form. And you'll notice this form is 11 pages, so it's a lengthy form. But even though it's 11 pages, you're not really filling out all that much. So we're going to put the policy number 124506, and then we're going to put the name, and then address, all basic information that you have. And then you're going to be initially, you're going to be dating 02/27/2022. And then we're going to come here, and thankfully it is, so then we're going to go to designating your primary beneficiary. We're going to fill out all the same details. The trust, we're going to put the address. We're going to put the percentage of the proceeds at 100%. We're going to put the country of citizenship as the US of A. The relationship to the insured is my trust. Then we're going to put the date the trust was created. Then we're going to fill in the rest of the details, the taxpayer identification number, and then that should be a dash. No, there we go. And then we're going to put no. So it gives you the option. Yes, I want to include future children of the insured as primary beneficiaries. That's a convenient feature where if you're listing individuals such as your children, you can automatically incorporate additional children, even if you haven't had them yet. This is a really nice feature, aside from the fact that, again, we don't want to put people. The reason we don't want to list people as beneficiaries is because people can die before you or at the same time as you, or even before, or I'm sorry, even after you, but before they're able to collect the benefits. And I'm going to tell you the story about the Yates that I posted on Facebook earlier today. So we've got all of this. The living trust. This is the option that we would do. So I'm sorry, and I didn't look at this form, so I apologize. I was just pulling up one, so I wouldn't put that information here. They have a space to go to a trust. So we would choose option C. So that's good to see that they have a specific designate. Then you have the contingency beneficiary. If you're using a trust, you don't have to worry about doing contingency beneficiaries on the forms themselves. And that's because the trust already has a contingency beneficiary. And in our case, we have a contingency to the contingency beneficiary. We always ask that our clients give us 3 levels. And that's a great estate planning approach, because even though we feel comfortable, and a lot of couples, we run into this scenario where they say, I want for my spouse to handle everything. I want them to be the executor. I want them to be the successor trustee. I want them to be the beneficiary. So, okay, we're good. But then you and your spouse might die at the same time or within a short window of opportunity. So now we need the kids. That's usually what comes up. So they give us the names of the kids. But again, parents and kids oftentimes find themselves in the same space, or traveling together, or being around one another. So let's say that now that the world is getting ready to open back up March 1st, where we're not even going to have to wear masks, let's say that now you book a trip. For instance, my family, a lot of them are going to Hawaii coming up real soon. So we get all of these people. We get mom, dad, we get son. They're going to Hawaii. They're all taking this trip out to Hawaii. Well, I'm knocking on wood because that's my family and I don't want this to happen. But let's say that the plane goes down. Now you had your spouse as your primary beneficiary and you had your child as your contingency beneficiary. Now, guess what has to happen to all of those assets? Well, even though you listed the spouse and the child as the beneficiary, it still has to go through probate court. And all because you stopped at 2 levels, even though there's a pretty good likelihood that those 2 levels could pass simultaneously because you're together. And the more you're together, the more there's a chance that something can happen to all 3 of you, or all 5 of you, or all 7 of you. That's why we don't want to put people as beneficiaries, because people can die at the same time as you or within a short period of time. So we're going to not worry about a contingency beneficiary because we have that in the trust. We're going to fill out these details, and then it says if the beneficiary dies within 30 days after insurance death, the beneficiary will be considered to have predeceased died. That's a terrible, terrible policy that I see in a lot of wills. The reason why is because who cares if the individual didn't live beyond 30 days? Like, what is this magical timetable of 30 days? I get it from a social policy standpoint that we want a cooling off period, but people don't always live beyond 30 days. Why should they be denied the benefit because they didn't make it an extra 30 days? And again, I'm going to show you an example, a real life example for a client that I'm going to probate court on tomorrow where this happened. So anyhow, you've got it filled out. You're then going to sign. You're going to date it. This one requires a witness. So it's good to see that here's another scenario where they're just looking for a witness. It cannot be one of the beneficiaries. Do not use a witness who's one of the beneficiaries, whether you're using your trust or you're using the individual. Go to a neighbor, go to an enemy, go to a bank and ask the teller. Don't use any of the beneficiaries or trustees. Then at which point it's asking for the signature of these other instances, signature of an irrevocable beneficiary. Remember, if you have an irrevocable living trust, the beneficiary is going to be someone else. So it needs to be signed by them. You're then going to initial, you're then going to date, and then it's giving you several options as to how you can submit the form. This doesn't really make very much sense to me because it says by phone. Like, how can I submit a form via phone? But hey, you can call and find out. You would fax it and mail it. I recommend always do every one of the options. If it allows you to email, email it. If it allows you to upload it, upload it. If it allows you to mail it, and fax it. The reason why is because this is too important. If you have a $500,000 life insurance policy, but you fail to actually add the beneficiary, then you just wasted money because now your heirs are going to have to go through probate court. And I just had to do that Friday. There was an individual, a young man, my age, 40 years young, passed away last year, I believe. Yeah, it was 2021. And he had taken out a $300,000 life insurance policy, which is great for his wife and his 2 children. That's good. That's really, really good. I recommend doing that. It's a tremendous idea. Please go get life insurance because it's a way to build generational wealth. However, you can't stop there. It's not enough to get a life insurance policy. You have to add a beneficiary. This young man never added a beneficiary. So now his wife has to come to our firm in order to go through probate court. The bond on a $300,000 life insurance policy that has to be paid by, in this case, the independent administrator, $1,900. That's how much the independent administrator had to pay just for the bond alone. The court cost, $600. Publication, $250. Normally, I'm doing this one pro se, but normally they'd be looking at legal expenses of anywhere from $5,000 to $7,500. There's also the notice that has to go out to heirs. In this case, because there are minor children, they're going to have to open up an additional probate estate to be established as the guardian for those minor children. So you're potentially talking about anywhere from $12,000 to $15,000, which could have all have been saved just by doing this, just by putting the information on the beneficiary designation form, signing it, having a witness, uploading it, and then mailing it and faxing it. That's how important this is. You could save your loved ones $15,000 by doing a simple process that, as you saw, would take us about 5 minutes. It's not hard. You just have to do it. By putting the trust as the beneficiary, you're now going to fund the trust with this life insurance policy. So in my case, and I pulled it out, so I have this trust, or I'm sorry, not trust, this life insurance policy. If you have AAA, AAA offers life insurance. They offer life insurance at a very low rate to start, and then the older you get, the more it increases. I didn't read all the fine print when I signed up, and I didn't see that it was going to be increasing. They got me. They said, sign up for a $300,000 policy for as low as $16. I jumped at it, sent it off with the check and said, okay, sign me up. Well, as it turns out, it increases as I get older. I'm okay with it because in my opinion, I don't think that I'm going to live to this old age. I don't eat well. I don't take care of myself like I should. I hope to be able to see my daughter graduate college. That's kind of the milestone that I want to stick around for. After that, I'm good if I don't make it. But I got this life insurance policy. However, I had to fill out the beneficiary designation form. They didn't offer the option online. So I had to fill it out, and then I had to mail it, I had to upload it, and I kept several copies. You need to make sure that the forms get filled out and sent. That's the responsibility of you as the policyholder. If you don't, you've essentially just wasted money, because now your loved ones have to go through probate court, and we don't want that. It's expensive, it costs a lot of money, it takes a long time, and it's unnecessary. All right, so we have some questions. Is it advisable to set up a separate trust if you own a business? That's a great question. So my answer is yes. It's advisable to set up a trust in all circumstances, whether you have a business or you don't. If you have a business, you can name the trust as the managing member for the business. So I'm going to show you that as an example. So if you have a business and you have not set up the succession planning, if something happens to you, that business now has to go through the probate process. So Illinois Secretary of State Business Search. We're going to come here, I'm going to click search, I'm going to hit submit once again, and I'm going to type in trustware. All right, so here's a company that our firm set up their LLC. Well, I'm sorry, we didn't set up the LLC, we created a trust for the LLC, and then we had the trust established as the managing member. So when someone goes and searches for this company, you'll see the name of the company is Trustware Solutions. The principal office is also right here in South Holland. However, the agent information is our firm. So now somebody who's going and searching for this company, they have no way of knowing who the managing member is, because usually they'll try and associate it with the registered agent. Our firm is the registered agent. We are not the managing member. When they scroll a little bit further to see who's the managing member, well, the managing member is the trust. No details are available. So for the question of if you have a business, is it wise to set up a separate trust? The answer is yes, because now not only has this business protected the identities of the managing member or members, it's also inherently taken care of the estate planning. It's already established inside of the trust agreement what is to happen with the business, what is to happen with all of the percentages and all of the shares, should anything happen to the managing members. Each of the managing members or each of the beneficiaries are already accounted for, and the business is protected. So yes, it is a fantastic idea to set up a separate trust if you own a business. Okay, so what happens when someone names a minor as a beneficiary and not the trust? Also, can you exclude your minor's other parent from taking over guardianship of your child using a trust? So those are great questions. And the answer is, if you name a minor as the beneficiary and not the trust, whomever becomes the legal guardian for that minor is now going to have essentially authority over what happens with that asset. And that's a very dangerous and slippery slope. And that's the reason why you don't want to do that. One of the things that we see is that when a minor is listed as the beneficiary and an adult, whether it's their biological parent or it's an uncle or an aunt, once they find out that that child is due to receive lots of money, that now becomes their motivation for becoming their guardian. Not the fact that they want to take care of that child, but they want to gain access to that money. Part of the reason why you want to go with the trust is because not only do you want to specify, hey, if something happens to me, I want my minor child taken care of, you also want to specify who controls the purse strings, who has access to all of this money that you want to now go to that child. That's what the trust enables you to do. So in my case, I have a minor child. My daughter's 12 years young, and there's money that's going to be available through all these life insurance policies. The ones that I told you I made the mistake on, that thankfully you're offering me the opportunity to get right. Well, in my scenario, I want for those funds to cover the property taxes for the property that I want for her to be able to live in. I want for those funds to also cover the insurance, homeowners insurance, all of the utilities. I don't want there being any issues with the house being maintained for her to live in. So because of that, my colleague, Attorney Jonathan Womack, who's my successor trustee, in addition to my younger brother, Marlon A. Reed, they have the specific instructions. My daughter's mother is going to be the guardian. I've put that in my will. I'm 1,000,000% certain that's how it would shake out, even if I didn't have them in my will. And even though I would feel very comfortable and confident with all of the money going to her, so that way she can make sure that everything's taken care of, because I have specific wishes, I've specified that in my trust. And even though it's for the benefit of my daughter, I have 2 individuals in place who are going to take care of the details of making sure that the money is being used for whom I want. So that's the advantage of the trust is, yes, it ensures that no matter who steps up and says, I want to be the guardian, the money is controlled in the way that you want it by the people you want to control the money. So thanks so much for that offer of being a licensed professional who can help me replace that AAA term policy. I'm still young and can get approved for a much better plan. That's something in which I'm amenable to discussing right now. I feel pretty decent because, like I said, I don't really see myself going for too much longer. But thanks for that offer. I appreciate that. And that is something that I would be open to discussing whenever time is available. That's the one thing I don't have very much of. So that's the commodity in which I'm always fighting with. Average cost to set up a revocable trust. So that's something that I'm more than happy to discuss. Anybody who's interested in having a revocable trust set up, always feel free to reach out. I don't like quoting prices or anything like that because this is not a solicitation. I do these workshops for knowledge and knowledge sake only. If you're interested in actually going with our firm or any firm, I recommend contact. So feel free to reach out. You can always call our office. Our information is available. You can go law offices of Mario A. Reed on Google. Reach out. We're happy to discuss it. So how often do you need to review your trust? That's a great question. And the answer is as often as life changes. Sometimes life changes once a year. Sometimes it changes 3 times a year. If somebody has died, if a trustee, a successor trustee, or a successor beneficiary has died, you need to review your trust. We get a lot of clients and we're coming up on year 3. So at the end of next month, so in 30 days, it's going to be 3 years. March 27th of 2019 is when I started the firm. We're going to be hitting the 3-year mark, March 27th of 2022. But in those 3 years, we've seen easily 10 different clients who they've changed their minds as to who they want to get the house, who they want to be responsible for carrying out the wishes, sometimes as often as 2 and 3 times in a year. How often you need to review your trust is how often things change. Whether you have new grandchildren or children, whether one of your chosen successor trustees dies before you. Anytime that there's a change or something that needs to be changed, that's how often you should be reviewing your trust. So there is no kind of guaranteed time. I would recommend at least once every 5 years, but there's a good chance that it could be once every 5 months, depending upon what's going on in your individual life. Everyone's trust is specific. Let's say that you get new assets. So in my case, planning on purchasing a new investment property. Even an investment property needs to have a succession plan or an estate plan in place, because while it's my goal to fix the property and then sell it, if I die before that happens, I need to have a succession plan so that my loved ones don't have to go to probate court involving my investment property. So every single asset that's being added, let's say that I get a new life insurance policy because I've talked with a licensed professional and they've recommended a different policy approach. Well, I need to now have my trust reviewed because I need to make sure that my trust is listed as the beneficiary. And then inside of my trust in the Schedule A, I need to list the trust so that my loved ones or whomever is going to be the successor trustee knows that there's another asset that's out there. So great question. Any other questions? At this point, we are now at the 10 o'clock mark, and it's my goal to stick around till 10:15. Thankfully, Ariel was successful. They went 3-0 yesterday, and they have no volleyball today. But I plan on tackling some work that I'm behind on, and today's going to be the day that I do it. So any other questions? And thank you for everyone who's asked questions. Thank you to everyone who's attended, everyone who has liked, loved, and commented. I greatly appreciate it. as I like to know that I'm not just here talking to myself. So many, many things. Okay, once you set up a trust, who manages the documents for you? For instance, making changes. Is it the attorney who prepared the document? So that's a great question. And the answer is it's up to you. For a lot of our clients, once we've set up the trust, if they're adding new assets to the trust, they can just write that information down themselves. Now, if they're making changes, again, it's going to depend on what type of change. Let's say that they would change banks. So if you go from Bank of America to Chase, you don't need to come back to the attorney to have that change made because that's done through Bank of America and Chase. You just need to indicate that inside of the trust. Now, let's say that you want to change who's the successor trustee and who's the beneficiary. That's a change that you do need to come back to our firm so that we can do, because we now need to do an amendment to that trust or a trust amendment. That's a major change which requires new documentation. Now, in terms of who manages the documents, again, that part's depending upon what type of management of documents you need. Our firm, we provide 2 copies, a bound original copy and a bound color copy of the documents. And in terms of managing it, you manage it. You just keep it at your house, or you keep it in a safe deposit box, or you give it to your successor trustee, however you want to manage that document. We also scan the documents and we send you a digital copy via email. So that way it's always in the cloud. As you get new documents, our firm, in our case, we print, have them bound, give them to you so that way you have them. But it's up to you how you manage the documents, and it's up to you how those changes are made. If you are making substantial changes to the trustee, to the name of the trust, to the beneficiaries, those are changes which are going to require an amendment. And yes, you have to go back to the firm. If you're making changes to the assets or adding new assets, such as bank accounts or insurance policies, those are changes that you can typically do yourself. You just need to write that information down inside of the trust agreement so your successor trustee knows that there are new assets. So really good question. Thank you for that. Any other questions? Any other questions? Like I said, stick around for another 6 minutes. So I want to make sure to get all of the questions answered. Today's workshop, once again, was about funding the trust. The trust needs gas. The trust is a car that helps your assets get from one place to another. You have to put the assets in the trust, and that becomes the fuel which moves the assets from you to the destination of your beneficiaries. That's what today's workshop has been all about. It's about funding the trust with the assets. If it's an insurance policy, you need to list the trust as the beneficiary. If it's a bank account, you can either open up the checking account in the name of the trust, or you can list the trust as the beneficiary. If it's a vehicle, let me show you how to do that. So in the state of Illinois, you can actually transfer your vehicles into the name of a trust. So Illinois vehicle title transfer. Okay, so we have title and registration, and we are going to go to transferring plates, title and registration. So we're going to go transfer plates, and then we're going to come here. So the application, electronic registration and title, continue the application, and then you're just going to fill in these details. You can do that online. You're going to put in your name, you're going to put in your driver's license, you're going to put in the last 4 of your social security number. Then from there, you're going to list the trust as the new vehicle owner. You can put your vehicles in the name of a trust. We oftentimes don't go that route because then you're paying $90 for that, $95 for that transfer title fee, but you can do it if you like. If you have a boat, if you have a mobile home, all of those assets can go in the name of the trust, and then the trust is inherently going to have that estate plan. That's the virtue of it. Any other questions? Any other questions? So one of the last things that if a rental property is from another state, must the trust be created in that foreign state? Example, I live in Illinois, the rental is in Louisiana. So the answer is no. It's just like the case of a business. You can have a business that's registered in the state of Illinois serve as the owner for a property in Louisiana or a property in Indiana. I'm actually getting ready to do that for a client that has, I want to say 10 different lots right on Indiana Beach. And they want for all of those properties to be in their LLC, which is a series in the state of Illinois. Same case for a trust. Your trust can be created and set up in the state of Illinois, and then you can have the property in Louisiana transferred into the ownership of the trust that was created in the state of Illinois. Now, I don't recommend doing that. And the reason why is because if there's ever any issue with the property down in Louisiana after you pass away, because the property is situated in the state of Louisiana, Louisiana law governs and controls. So because of that, it only makes sense to have a trust that was created using Louisiana law. Now, we've done this before. We did it for a client out in North Carolina, Mr. D. Shout out to Mr. D, great client. We actually, here in Illinois, we went and we looked up the North Carolina law, and we checked the trust code for the state of North Carolina, and we created a trust that was based and rooted in North Carolina law. And while here in Illinois, we communicated remotely with Mr. D and then had him execute all the documents electronically. This was during the height of the pandemic. And now, even though we're here in the state of Illinois, we created a North Carolina trust, which is consistent with North Carolina trust law. And then he transferred the property out of his name into the name of his North Carolina trust. We prepared the deed in trust, mailed it out to him. He signed it, got it notarized, took it over to the county recorder himself and recorded it. And now his property in North Carolina belongs to his trust that's based out of, or not based out, but was created pursuant to North Carolina law, even though we're here in Illinois and we practice in Illinois. So even if you live in Illinois, I would recommend have a trust created pursuant to Louisiana law, and then have the Louisiana property conveyed into the trust that was created pursuant to Louisiana law, trust law. And the reason why is because if there's any issue, it's going to be governed by Louisiana law, not Illinois law. So it doesn't make a whole lot of sense, in my opinion, to have an Illinois trust, which has its own set of laws, the Illinois Trust Code that governs it, even though the property has to be governed by Louisiana law, because the property always dictates the law that's going to govern it. So if the property is situated in Louisiana, and again, the hope is that by having that trust, it's not actually going to have any conflict, but we never know. And because we never know, it's not worth risking it. So great question. All right, do each individual person have to have a trust, or can a married pair have one trust for everything? That's a really good question. And the answer is, it depends on the married couple. We get a lot of married couples where they want to have their own separate trust. And that's because in 2022, we have so many blended families. So let's say that there's a married couple and each of them had their own property before they got married. And now that they've gotten married, they still have their own separate properties. One individual's renting the old property out, the other, and then they're living in the property that they bought together. Or let's say that they buy a separate property together. So they've got 3 properties, one that they live in, and each of them are renting out their old properties. Well, because they have 3 properties, we're going to do 3 trusts anyhow. That's just how our firm does it, because remember, we don't want the cross liability. But now, because they have these 2 separate properties, which essentially are their own individual properties, and a 3rd property, which is theirs collectively together, they oftentimes want a separate trust, which husband has the trustee capabilities himself for the property he had before they joined the marriage, and then wife has, or spouse has, their property in a separate trust where they're the trustee for, and then they have one together. We just did this for the, let's just call them the Berries. That's not their name, but we'll call them the Berries. One had a condo, one had a townhome, and now they live together in a single family residence property. For the one who had the condo, he's the trustee and the beneficiary for that trust. For the one who had the townhome, she's the trustee and the beneficiary during her lifetime for that one. And then for the single family residence they have together, they're both the trustees and the beneficiaries during their lifetimes. So 3 different trusts, each of which have different dynamics. Each of them have said, if after both my spouse and myself die, we then want for the property to go to my family for the condo, her family for the townhome, and then our collective family for the single family residence. So it depends on the situation. Let's say that you're a married couple where you bought a house together and you only have that one house, then yes, you typically only need one trust, but it depends on the circumstances. And that's one of the reasons why all of these kind of online platforms of LegalZoom, as well as even the kind of do-it-yourself that you see through Susie Orman, it's great that it's an available option, but just please beware, because there isn't a one-size-fits-all when it comes to estate planning. And if you don't understand the dynamics of what you're signing up for, you could be doing more harm than good. So great question. So the answer is, it depends. It depends on the circumstances. What if you have several checking and savings accounts at different banks and have beneficiaries but want to put in trust? Do you amend with the individual banks to make changes? Great question, and the answer is yes. Anytime that you have financial assets, you have to go to the financial institution and add the trust as either the beneficiary, or you have to create a new account that is going to become the owner, and then you transfer the assets out of your name into the name of the trust account. Have a client, Miss A, in Olympia Fields, and on March, what day is it? I believe coming up this week, March 4th, whatever Thursday is of this upcoming week, I'm going to spend the entire day. I've blocked out the entire day where we're going to go through all of her financial assets. She has a life insurance policy with Northern Trust. She has AARP life insurance accounts. She has numerous checking accounts. We are going to spend the entire day on the phone. Thank you. March 3rd it is. We're going to spend the entire day on the phone, as well as even traveling to these institutions to have new accounts created in the name of the trust. Then, after we have the new accounts created in the name of the trust, they're going to transfer the funds out of these investment accounts into her new trust account, the names in the name of the trust, and then close out the old accounts in her name. That way, the trust is now the owner and all of the estate planning is done. She has one child, and that child right now is in his early 20s. According to Miss A, she doesn't feel confident that he's going to be responsible. She believes that he would spend more money on traveling, which he loves to do, and kind of burning through it, as opposed to preserving it for housing and things like that. She specified that 80% from the sale of the house has to be used for his housing. He can use it to purchase an investment property. He can use it to purchase a condo. He can use it to purchase a single family residence, but it has to be used for housing. That's the virtue of a trust. And that's part of why it's to your advantage to move all of those assets into a trust. So to answer your question, if you have several checking and savings accounts at different banks that have beneficiaries, but you want to put in trust, yes, you do have to go to the bank. You have to create a new account in the name of the trust. You have to have them transfer the funds from the checking account that's in your name into the name of the account for the trust. That is the process. And that's part of what that's the primary purpose of today's workshop, is to impress upon you the importance of doing it. So many people stop at just getting the trust created, and then they don't finish the job. You have to finish the job, because if you don't, then at which point you've really just wasted so much time, effort, and money by having the trust created. You have to fund the trust. You have to properly title assets in the name of the trust. Any other questions? Any other questions? I want to make sure that everyone's 100% clear on what the purpose of today's workshop was, and that you've gotten all those questions answered. If there are any other questions you have, feel free to post them. If not, we're going to be getting ready to sign off. Again, I want to thank everybody for attending. Hopefully you're enjoying this beautiful spring-like weather that we've been experiencing. Ideally, you're also getting some type of information regarding Black history. We are 2 days away from the end of it. It's still Black History Month. I like to call it American History Month. And that's what Black history is. So go learn something, find out about something you didn't know. If you don't have anything that you want, read about the New Negro movement. As one last fact, did you know that the Harlem Renaissance was never called the Harlem Renaissance during the time period that it was happening? It was called the New Negro Movement, and that's from an essay of Elaine Locke. Please go and research the New Negro Movement. Elaine Locke, one of the brightest philosophers and minds this country has ever known. Most people are unaware of him because we haven't been taught it. That's my parting Black history fact for the month. Thank you all who attend. Thank you, Ms. Renee, greatly appreciate it. And everyone have a fantastic rest of your Sunday and weekend. Please stay informed. Take care all.